Welcome back to LexTalks, Legal Topics Simplified, your guide to navigating the world of law.
Absolutely.
Today we're diving deep into a topic that's, well, I think it's crucial, especially for all of you, as Indian law students.
Definitely.
Fundamental rights in India.
That's right. These rights they're really like the bedrock of Indian democracy. They're not just, some abstract legal concepts.
Okay.
They're the guarantees that protect, your freedoms, ensure that you can live with dignity.
Okay, so let's unpack this.
Sure.
We know these rights are enshrined in Part 3 of the Indian Constitution.
Yes.
Specifically Articles 12 to 35.
Right.
But here's a question for you.
Okay.
Why are these rights so fundamental? What makes them different from other legal rights?
That's a great question. One key difference is that fundamental rights are considered inherent and inalienable.
Okay.
They're not granted by the state. They're recognized as pre-existing rights that every individual possesses by virtue of being human.
So it's like the Constitution is saying, hey, these are rights you already have,
Yeah.
and we're going to make sure the government can't mess with them.
Exactly. They're meant to act as a shield against any arbitrary or excessive actions by the state.
Right.
Think of it as a safeguard against tyranny, ensuring that the government doesn't overstep its boundaries and infringe upon your basic freedoms.
That makes sense. Now, our sources lay out 6 fundamental rights. Right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and the right to constitutional remedies. Did I get them all?
You got them all.
Yeah.
And each one of these rights has been the subject of intense debate and legal interpretation over the years.
Yeah.
It's not just a dry list of articles. It's a living, breathing framework that's constantly being shaped by court judgments and societal changes.
All right, let's dive into some specifics.
Okay.
The right to equality, Articles 14 to 18, is all about ensuring everyone is treated fairly under the law. But Article 14, with its guarantee of equality before the law and equal protection of the laws, always seemed a bit confusing to me.
Right.
What's the difference?
It's a subtle but crucial distinction.
Yeah.
Equality before the law basically means that everyone, regardless of their background, is subject to the same laws.
Got it.
No one is above the law, whether you're a politician, a celebrity, or an everyday citizen.
So no special treatment for anyone.
Well, not exactly.
Okay.
That's where equal protection of the laws comes in.
Okay.
It recognizes that sometimes treating everyone identically isn't actually fair.
Right.
It allows the state to create special provisions for certain groups that need extra protection.
So that's why we have laws specifically protecting women and children, for example.
Exactly. Article 15 allows the state to make these special provisions
Okay.
because it recognizes that true equality sometimes means acknowledging differences and providing additional safeguards for those who are more vulnerable.
Okay, that clears things up a bit. Now let's talk about the right to freedom, Articles 19 to 22.
Sure.
This one covers a lot of ground. Freedom of speech, assembly, association, movement, residence, and profession. These are pretty big deals, right?
Absolutely. They're the cornerstones of any democratic society.
Yeah.
But here's where it gets tricky.
Okay.
These freedoms are not absolute.
Okay.
They have reasonable restrictions.
So I can't just stand on a street corner and shout whatever I want.
Well, you can shout, but there might be consequences.
Oh, yeah.
If what you're shouting incites violence, hatred, or poses a threat to national security,
Right.
the state can impose restrictions on these freedoms if it's necessary to maintain public order, protect the rights of others, or prevent chaos.
Makes sense. You can't just yell fire in a crowded theater.
Right.
But one thing I found interesting in our research is that the freedom of movement doesn't include the right to strike.
Right.
Why is that?
That's a good question. It highlights the fact that even fundamental rights have limitations. The right to strike, while important for workers' rights, can sometimes disrupt essential services and impact the public.
Yeah.
So it's been subject to specific regulations and legal frameworks.
So it's all about finding a balance between individual freedoms and the needs of society as a whole.
Exactly.
Speaking of balance, one right that seems particularly crucial is the right to life and personal liberty under Article 21.
Absolutely. It's often called the heart and soul of the Constitution.
Right.
Because it safeguards the very essence of human existence.
Yeah.
But it's not just about staying alive.
Right.
It's about living a life with dignity.
I remember from my classes that the interpretation of Article 21 has evolved significantly over time.
You're absolutely right. It's been expanded through judicial pronouncements to encompass a wide range of aspects that contribute to a life of dignity.
Like what, for instance?
Well, it now includes things like the right to a clean environment, the right to education, the right to a speedy trial,
Wow.
and even the right to die with dignity in certain circumstances.
Wow, that's quite an expansion.
It is.
So Article 21 isn't just about protecting you from physical harm.
Yeah.
It's about ensuring you have the basic conditions necessary to live a fulfilling life.
Exactly, and that's what makes it so powerful.
Yeah.
It recognizes that human life is multifaceted and deserves protection in all its dimensions.
So if someone's basic rights are being violated, how do they actually enforce these fundamental rights? I mean, the Constitution is a document. How does it translate into real-world protection?
That's where the right to constitutional remedies comes in.
No.
Article 32 is like the guardian of all the other fundamental rights.
Okay.
It gives you the power to go directly to the Supreme Court if your rights are violated.
So you can actually sue the government if they're infringing upon your rights.
You got it. Article 32 allows individuals to file what are called writs, legal tools that can compel the government to act or refrain from acting in a certain way.
I remember learning about the different types of writs.
Yeah.
Habeas corpus, mandamus, prohibition, certiorari, and quo warranto. I always found those terms a bit intimidating.
Yeah.
Can you break them down for us?
Sure. Think of them as different legal weapons in your arsenal to fight for your rights.
Okay.
For example, habeas corpus literally means you shall have the body.
Okay.
It's used to challenge unlawful detention.
Okay.
If someone is being held prisoner without justification, you can file a writ of habeas corpus to demand their release.
That sounds like a pretty powerful tool.
It is.
What about the other writs?
Well, mandamus means we command.
Okay.
It's used to order a public official to perform a duty they are legally obligated to do.
Okay.
Let's say a government department is delaying issuing you a passport despite you fulfilling all the requirements.
Right.
You can file a writ of mandamus to force them to issue it.
So it's a way to hold the government accountable for its actions.
Exactly. And the other writs have their own specific purposes.
Okay.
Prohibition is used to stop a lower court from exceeding its jurisdiction. Certiorari is used to review the decision of a lower court, and quo warranto is used to challenge someone's right to hold a public office.
So Article 32 really gives teeth to all the other fundamental rights
It does.
by providing a mechanism for citizens to actually enforce them in court.
Precisely. It ensures that fundamental rights are not just empty promises written on paper. It makes them real and enforceable, giving you the power to protect yourself from any infringement by the state.
This has been an eye-opening discussion so far.
Yes, it has.
We've covered a lot of ground in just this first part of our deep dive into fundamental rights. But before we move on, I want to turn to you, our listener.
Yes.
What are your initial thoughts?
Yes.
Which of these rights resonates most strongly with you and why?
It's an important question to consider.
Yes.
Because these rights are not just theoretical concepts.
Right.
They impact your everyday life, your freedoms, and your future as legal professionals.
Exactly. So take a moment to reflect on what we've discussed so far and be prepared to dive even deeper in part 2 of our LexTalks journey.
I can't wait. Welcome back to LexTalks.
Absolutely. Last time we, I guess, laid the groundwork discussing what makes these rights so fundamental
Right.
and how they act as safeguards against state overreach.
Yes.
We also unpacked some key articles like Article 14 on equality and Article 21 on the right to life and personal liberty.
Exact.
Today, let's explore how these rights play out in real-life situations, through landmark cases.
Yes, absolutely. After all, the law is not just about abstract principles.
Right.
It's about how those principles are applied and interpreted in practice.
I love that perspective.
Thank you.
So which case should we tackle first?
Well, how about we revisit Article 19
Okay.
and the right to freedom,
Right.
particularly freedom of speech and expression.
Right.
This is a right that's often hotly debated,
Yeah.
with people having strong opinions about where the lines should be drawn.
It's definitely a right that's constantly being tested and redefined, especially in today's world, with the rise of social media and new forms of communication.
Exactly. And the courts have had to grapple with some complex questions about how to balance the freedom of expression with other important considerations like national security, public order, and the rights of others.
So where do we even begin to unravel this tangled web of legal precedents?
Okay, well, let's start with a landmark case from 1950. Ramesh Thapar versus State of Madras.
All right.
This case involved a journal
Okay.
that was banned by the Madras government
Okay.
for publishing articles critical of the government's policies.
Got it.
The Supreme Court ultimately struck down the ban, emphasizing that freedom of speech and expression is essential for the functioning of a democracy.
So even if the government claims it's acting in the interest of national security, the courts can step in if they feel those actions are disproportionately restricting free speech.
That's the essence of judicial review, you see. The
Yeah.
courts act as guardians of fundamental rights, ensuring that the government doesn't overstep its bounds. Of course, it's a delicate balancing act. The courts have to weigh the importance of free speech against other legitimate concerns.
Can you give us an example of how the courts have balanced these competing interests?
Sure, take the case of Maneka Gandhi versus Union of India
Okay.
that we touched upon earlier.
Yes.
In this case, the court, while upholding the right to travel abroad,
Okay.
recognized that restrictions could be imposed on this right in the interest of national security.
So it's not an absolute right to travel wherever you want, whenever you want?
Right. The court made it clear that the government can impose restrictions
Okay.
if they are reasonable and proportionate to the threat being addressed.
Okay.
For instance, if someone is suspected of terrorism or espionage,
Right.
their right to travel might be curtailed to protect national security.
That makes sense. It's all about finding that sweet spot between individual freedom and societal well-being.
Yes.
Now, let's move on to another aspect of the right to freedom,
Okay.
freedom of assembly.
Yes.
We talked briefly last time about how it doesn't include the right to strike. Are there any other interesting nuances to this right?
Well, one case that highlights the limitations on freedom of assembly is Hamat Lal Case Shah versus Commissioner of Police.
Okay.
In this case, the court upheld a rule
Okay.
that required prior permission from the police
Okay.
before holding a public meeting on a public street.
So you can't just gather a crowd anywhere, anytime you need the government's permission.
Not exactly. The court's reasoning was that the freedom of assembly
Okay.
doesn't grant you an absolute right to hold a meeting
Okay.
wherever and whenever you please.
Okay.
The state has a legitimate interest in regulating the time, place, and manner of assemblies
Okay.
to ensure public order and safety.
So it's about preventing chaos,
Yeah.
not stifling dissent, right?
Right. The court has consistently emphasized that any restrictions on the right to assemble
Yeah, okay.
must be reasonable and aimed at maintaining public order,
Okay.
not at suppressing legitimate expression or protest. For example, the government can't ban a peaceful protest just because they disagree with the message being conveyed.
Okay, I'm starting to see how these cases help us understand the fine print of these fundamental rights.
Good.
Now let's shift gears to Article 21,
Okay.
the right to life and personal liberty. We talked about how its interpretation has broadened over time to include things like the right to a clean environment
Yes.
and the right to education.
It has.
Are there any other landmark cases that illustrate this evolving understanding of Article 21?
Oh, there's so many fascinating cases that have shaped how we interpret this crucial right.
Yeah.
One that stands out is Francis Corley versus Union Territory of Delhi.
Okay.
From 1981, in this case, the court held that the right to life isn't just about bare existence.
Okay.
It includes the right to live with dignity.
So it's not just about breathing and having a pulse.
No.
It's about having the basic conditions necessary to live a life worthy of a human being.
Exactly. The court recognized that human dignity
Yeah.
is an essential component of the right to life.
This means things like having access to basic necessities like food, water, and shelter,
Yeah.
as well as being free from exploitation and inhuman treatment.
So how did this case actually impact the lives of people? Can you give us a concrete example?
Sure. This judgment had a significant impact on prison conditions.
Okay.
The court held that prisoners,
Yeah.
even though they are deprived of their liberty,
Right.
retain their fundamental right to live with dignity. This means they must be provided with humane living conditions, adequate medical care, and protection from cruel and unusual punishment.
That's a powerful example of how Article 21 can be used to protect the most vulnerable members of society.
It is.
Are there any other cases that have expanded the scope of Article 21 in significant ways?
Absolutely. The case of Bandhu Mukti Morcha versus Union of India is a landmark judgment that brought environmental protection under the ambit of Article 21.
Wow. So the right to a clean environment is now considered a fundamental right in India.
That's right. This case was a game changer for environmental law in India.
Empowering citizens to hold the government accountable for environmental degradation.
These cases show how the courts can interpret these rights in creative and impactful ways to address the evolving challenges of our time. It's like they're breathing new life into the Constitution, making it relevant to contemporary issues.
Exactly. The Constitution is not a static document.
Right.
It's a living, breathing framework that adapts to the changing needs of society.
Okay, I'm really starting to appreciate the dynamism of fundamental rights.
Good.
Now, before we wrap up part 2, I want to turn back to you, our listener.
Yes.
As future lawyers, you'll be dealing with these cases, these precedents.
Yes.
Which of the cases we've discussed so far has really stuck with you? What implications do you see for your future legal careers?
It's important to not just memorize these cases, but to understand the principles behind them,
Yep.
the arguments made, the dissenting opinions.
Right.
This is how you develop your legal reasoning,
Yes.
your ability to think critically and apply these principles to new situations.
Excellent point.
Thank you.
Keep those thoughts brewing, because in part 3, we'll move beyond individual rights and delve into broader themes like the relationship between fundamental rights and directive principles of state policy. We'll also tackle some controversial areas like the Ninth Schedule and its immunity from judicial review. Welcome back to LexTalks. In the last 2 parts, we really dug deep, I guess, into the 6 fundamental rights.
We did.
Exploring, their nuances and how they've been interpreted in landmark cases.
Yes, we've journeyed through articles, analyzed judgments, and even touched upon some of the ongoing debates surrounding these rights.
It's been quite a ride, but for this final part of our deep dive, I'd love to zoom out a bit.
Okay.
And explore, some of the broader themes that surround fundamental rights.
Sure.
One thing that always intrigued me is the relationship between fundamental rights and the directive principles of state policy.
Okay.
They both reside in the Constitution, yet they seem to have different roles to play.
Right.
Can you shed some light on this dynamic?
Absolutely. It's a fascinating interplay, really. You see, fundamental rights are justiciable,
Okay.
meaning you can approach a court to enforce them.
Okay.
Directive principles, on the other hand, act more like guidelines for the state to strive towards while formulating policies.
So they're like aspirational goals for a just and equitable society.
Exactly. Think of them as a blueprint for creating a society that upholds, social and economic justice.
Okay.
However, they are not legally enforceable in the same way as fundamental rights.
So what happens when a directive principle clashes with a fundamental right? Which one takes precedence?
That's a question that has been debated extensively in legal circles.
Yeah.
In the early years after independence, the courts often prioritized fundamental rights over directive principles.
Okay.
But over time, there's been a growing recognition that these two sets of principles are not mutually exclusive.
So they can coexist and even complement each other.
Precisely. The courts have started interpreting fundamental rights in light of directive principles, using them as aids to understand the true scope and intent of these rights.
Can you give us an example of how this plays out in practice?
Certainly, take the Chempakam-Dora-Rajan case, for instance.
Okay.
In this case, the Supreme Court struck down a Madras government order that reserved seats in educational institutions based on caste.
Okay.
Even though the government argued that it was trying to uplift backward classes, aligning with the directive principles.
So the court prioritized the fundamental right to equality over the state's attempt to implement a directive principle.
Not exactly. The court recognized the importance of both principles,
Okay.
but held that the government's method of implementing reservations was discriminatory
Okay.
and violated the individual's right to equality.
Gotcha.
The judgment paved the way for a more nuanced approach to reservations, balancing social justice with individual rights.
That's a great example of how the courts can harmonize seemingly conflicting principles. Now, another topic I wanted to discuss is the debate surrounding the Ninth Schedule and the immunity it grants to certain laws.
Right.
It's often called a shield against judicial review, isn't it?
That's right. The Ninth Schedule was originally intended to protect agrarian reforms and other social welfare legislation from being struck down by the courts on the grounds of violating fundamental rights.
So it was a way to safeguard progressive legislation
Yes.
and accelerate social change.
Precisely. The idea was to prevent the judiciary from hindering the government's efforts to bring about much-needed social and economic reforms.
But it sounds like this shield could potentially be misused to protect laws that might not be so well-intentioned.
That's a valid concern, and it's something that has been debated extensively. Over time, the Ninth Schedule has been used to include a wider range of laws,
Yeah.
not all of which are directly related to social welfare.
So there's a concern that this immunity could erode the very essence of fundamental rights.
Exactly. The debate revolves around finding the right balance between facilitating social change and safeguarding individual liberties.
So are there any checks and balances in place to prevent the misuse of the ninth schedule?
Yes, there are. In
Oh.
the Ira Coelho case, the Supreme Court clarified that laws included in the Ninth Schedule are not completely immune from judicial review.
So they can still be challenged in court.
Yes, but under specific circumstances, the court held that even laws under the Ninth Schedule can be struck down if they violate the basic structure of the Constitution.
Ah, so the basic structure doctrine acts as a safeguard,
It does.
ensuring that even the ninth schedule can't be used to completely override fundamental rights.
Exactly. It's a crucial check on the power of Parliament and a testament to the judiciary's role in protecting the core principles of the Constitution.
It's clear that fundamental rights are not just static provisions in a document.
No, they're not.
They're dynamic, evolving concepts that are constantly being shaped by judicial interpretations and societal changes.
And understanding this dynamism is crucial, not just for you as law students,
Right.
but for every citizen of India.
Yeah.
These rights are the bedrock of our democracy.
Yes.
And it's our collective responsibility to understand them, uphold them, and engage in informed debates about their scope and limitations.
Well said. It's been an incredible journey exploring the complexities of fundamental rights in India. I hope our listeners feel empowered to continue this exploration, beyond our LexTalks deep dive.
Absolutely. Engage with these rights, question them, debate them, and most importantly, use them to build a more just and equitable society.
Thank you for listening to LexTalks. Follow, subscribe, and stay notified for future episodes.